Greetings, I'm Shireen Misha. One of the primary goals of judicial review is to hold the government accountable. Accountability refers to the checking, controlling, or regulating of government in the case of judicial review, so that it is held accountable in relation to administrative law principles. It is not the only legal method by which public officials can be held accountable. Tort and contract actions as well as non-legal methods are also used. However, judicial review is the primary legal means of holding the government accountable. The court's role in acting as a check on the government differs from that of Parliament. Judges are independent of government. They are unelected and cannot hold the executive accountable unless a person or organization whose rights have been violated brings a case to them. Part 54.1 of the Civil Procedure Rules define judicial review and states, sub 2 in this section, A. A claim for judicial review means a claim to review the lawfulness of an enactment or a decision, action, or failure in relation to the exercise of a public function. Individuals or organizations affected by the exercise of state power can seek judicial review in the administrative court. The courts uphold the rule of law by ensuring that public bodies do not act beyond their legal authority. The courts ensure that government agencies act in a rational, reasonable, and proportionate manner. The court also guarantees that the public body follows natural justice norms. The court examines the state's procedure to determine that the standards of fairness and procedural integrity were followed. Ultimately, the courts will demand the executive power be exercised in accordance with the rights and freedoms guaranteed by the European Convention of Human Rights, ECHR. During the second half of the 20th century, the role of government expanded into areas where it had previously been passive. The welfare state was established and the government assumed responsibility for health, welfare, housing, immigration, and education. As a result, private individuals now have a greater ability to challenge the exercise of government powers. During the 1960s, Lord Reid in the House of Lords led the way in establishing a set of coherent judicial review principles. The law of procedural fairness was reformed first, followed by substantive review and aspects of the relationship between the law and the Crown. Finally, the jurisdictional review process was revisited and rewritten. In April 1999, the most recent version of the Civil Procedure Rule 1998 was introduced. It establishes a detailed procedure for bringing a claim before the High Court or the Court of Appeal. The Senior Courts Act of 1981 is the other major legal document that governs judicial review. The Civil Procedure Rule replaced Order 53 of the Rules of the Supreme Court. Now, let us distinguish between private and public law. A concept of law managing the relationship between persons, citizens, businesses, and the state is known as public law. Constitutional law, administrative law, and criminal law are all considered sub-disciplines of public law. According to this idea, private law, on the other hand, refers to the part of the civil law legal system which is part of the jus commune that involves relationships between individuals, such as the law of contracts or tort, as it is called in the common law, and the law of obligations, as it is called in civil legal systems. EHRA primarily covers claims against public authorities, but it also covers claims against private entities that perform public tasks. Because courts are defined as public authorities under Section 6, Sub 3 of the HRA. They are obligated by the ECHR's requirement in issuing judgments, even if they are only affecting private parties. The convention is said to have an indirect horizontal influence in this way. Thank you.
The case of O'Reilly v. McMahon has had a significant impact on administrative law. In the procedural sphere, it established or maybe resurrected a division between public and private law. In O'Reilly v. McMahon, 1983, the applicant had taken part in a prison riot at Hull Gaol, and the Board of Visitors lowered the remission of sentence as punishment. The applicants attempted to show that the Board of Visitors had acted in violation of natural justice standards. They attempted to accomplish this by issuing an original summons or writ. It was not disputed that the problem was one of the public law and that they could have sought judicial review if they had requested for leave within the requirement 3 months. In private law action, no permission from the court is required. The private lawsuit was found to be an abuse of procedure by the House of Lords, and it was dismissed. The claim was found to be a clear attempt to circumvent the protection afforded by Order 53. The Order 53 method also includes safeguards such as an initial leave requirement and unique time constraints to process the public interest form, groundless, meritorious, and tardy harassment of public officials, according to Lord Diplock. The Order 53 remedies, with the exception of damages, are discretionary. As a result, the court might consider the impact of its intervention on third parties as well as the existence of an equally effective alternative remedy. It can also take a broad look at the outcome of intervention. Despite the Law Commission's objective that procedural modification established in 1977 were not intended to create a rigid separation between public and private law proceedings, Lord Diplock created the exclusivity principle in O'Reilly, keeping public and private law rigorously different. Although a division between public and private law was formed before the time, the system was not exclusive. Professor Wade considers O'Reilly's declaration of the exclusivity principle to be a major setback for the administrative law. It's possible that seeking private law remedies through a judicial review application will be deemed an abuse of process. However, this has been necessary because the legislature foresaw the problem and defined the scope of judicial review in the Section 31 subsection 2 of the Supreme Court Act 1981. The fact that the procedural exclusivity has two independent juristic bases has a number of crucial repercussions. To begin with, there is no reason why exclusivity based on abuse of process and exclusivity based on Section 31 should be mutually exclusive. Second, the utility of the O'Reilly v. McMahon distinction between public and private law must be questioned. Until O'Reilly v. McMahon, substantive judicial review law had developed in both public and private contexts without the necessity for a general distinction, at least in declaration and injunction cases. Indeed, Lord Dunning's famous remark in Breen v. AEU that we now have a mature system of administrative law was stated in the context of a private law cases, and the two fields have seen a lot of cross-fertilization. The concept of legitimate expectation, for example, has occurred in both contexts. Nevertheless, since O'Reilly v. McMahon, a person who has been harmed by a public authority's action has had to first determine whether the dispute right was a public law right in which the case relief should be sought through an application for judicial review under Order 53 or a private law right which has to be properly enforced through an ordinary action. Thank you.
Hi, my name is Jashrich, and I'll be talking about the development of the rule in O'Reilly. Now, it's important to note that the exclusivity principle is not absolute, and over time, courts have developed exceptions to this rule in response to its harshness. Firstly, on multiple occasions, the court has allowed for a matter of public law to be used as a defense in both criminal and civil proceedings. In Wandsworth, London Borough Council and Binder, the House of Lords allowed a matter of public law, that is the lawfulness of the council's decision, to be used as a defense to private law proceedings. In this case, Binder was living in a premises rented out by the public authority, which had recently raised rent. And after Binder failed to pay rent, the public authority brought an action claiming for possession of the premises. And Binder's defense in this case was that the rent increase was outside the powers of the local authority and therefore void for unreasonableness. The question before the House of Lords was whether Binder could challenge the local authority's action by way of a defense on judicial review grounds, or whether he should have instigated separate judicial review proceedings by way of an application to the High Court. It was held that Binder's action could not be described as an abuse of the court process because Binder had not selected the procedure. He was merely seeking to defend himself. If public law interest required that people should not have the right to defend themselves, then that was a matter for Parliament to decide and not the courts. Now, similarly, in Boddington and the British Transport Police, the court allowed for the virus of subordinate legislation to be challenged in a criminal proceeding. Here, the defendant in a criminal proceeding on charges of smoking a cigarette in a railway carriage sought to argue that the Network South Central's decision to post notice banning smoking was ultra vires its powers to bring the relevant bylaw into force. The House of Lords stated that a defendant was entitled to raise that defense, and that if the defendant managed to rebut the presumption in favor of the lawfulness of the administrative act, the act had no legal effect at all, and the court could not find a prosecution. The House of Lords found that there was nothing in the act or the bylaws to prohibit the defendant from defending himself against a criminal charge on the basis of the validity of the decision to put no smoking notices in the carriage. However, the manner in which the relevant bylaw had been brought into force was not ultra vires, and accordingly the appeal was dismissed. Now, the courts have also established that the exclusivity principle does not apply in instances where the proceedings involve both public and private law elements. The main authority that substantiates this point is the case of Roy. Now, over a period of 8 years, Dr. Roy had periodically been absent from his practice, right? But his absence was always covered by a locum, and there were no complaints from his patient. Nevertheless, the Family Practitioner Committee decided that Roy wasn't devoting a substantial amount of time to general practices under the NHS, and subsequently cut his wages. Roy then litigated to receive the loss of his wages. On appeal to the House of Lords, it was held that when a litigant had a private law right in relation to a matter which involved an issue of public law, he was not precluded from pursuing his private law right. Here, regardless whether the right was statutory or contractual, it was a private law right. And in the words of Lord Lowry, Roy's private law rights dominated the proceedings. And accordingly, even though the public law issue could have been determined through a judicial review proceeding, this does not mean that he ought to be denied private law remedies. Later, Gayatri will speak more about Lord Lowry's dichotomy of the broad and restricted approach. Now, furthermore, the case of Andrew also provides where a case consists of both private and public law rights being challenged, that the applicant is not deterred from pursuing a private law action. Here, Andrew had been granted leave by the High Court for judicial review proceedings to challenge the validity of a bylaw of the Chartered Institute. However, he failed to observe the 3-month time limit, and then Andrew proceeded to commence a private law action alleging breach of contractual duty to exercise its bylaw-making powers fairly and to act fairly in its disciplinary proceedings. The Court of Appeal recognized that the Institute of Chartered Accountants was a public body, nevertheless held that there was a contractual private law right where private law proceedings are appropriate. Lastly, in determining if the exclusivity principle applies, the court will consider Parliament's intention when drafting the act in question, as seen in O'Rourke. Now, in this case, the plaintiff applied to the local authority for accommodation that was provided under the Housing Act 1985 on his release from prison. And Section 63, subsection 1 of the Act provides that the local authority is under a duty to provide accommodation in respect of those who are homeless and of our priority need. And this includes people who are vulnerable as a result of physical disability or any other special reason. Now, initially, the council refuses accommodation, but later on provided accommodation for 12 days and then evicted him on the basis that he was not, in their opinion, in priority need. Now, the plaintiff brought an private action against the council for wrongful eviction without providing alternative accommodation and claimed for damages. The House of Lords ruled that the question of whether Section 63 of the Housing Act gave rise to public or private law proceedings depended on the intention of Parliament. The House of Lords followed the decision in Cook's and Tannen and took the view that it was unlikely that Parliament had intended to create the legislation to create private law rights of action in favour of plaintiffs. Therefore, he was not entitled to damages for wrongful eviction. Two reasons given by Lord Hoffman. Firstly, the duty to provide accommodation was a matter of public law and the Act. And secondly, the provision of accommodation was largely dependent on the housing authority's judgment and discretion. Accordingly, it was unlikely that Parliament had intended Section 63 to give rise to a private action. That's all from me. Thank you so much.
After the landmark case of O'Reilly has been decided, the general rule that has been set is that the public law claims must be brought by judicial review process, otherwise it would amount to abuse of process if claims are brought under different action. As per Lord Diplock, the underlying principle of Order 53 is to provide protection towards public authorities where their rights have been infringed. Consequently, there were criticism raised upon the rigidity of exclusivity principle in O'Reilly and Macman, whereby public law matters only should be pursued through the application for judicial review. Conversely, private law matters should be dealt by ordinary action. A proper identification of criticism is laid in the case of Anderson Asphalt and the Secretary for Justice, where the distinction between private and public law has been regarded as something of a headache. Moreover, Professor Jolowitz came to find that his claim was merely rejected on the basis that the wrong form of action was taken and not because it lacks locus standi or it is without substance. This purely shows how the distinction as to the law and the form of action can lead to such an absurd outcome of the decision, and which is why it is criticized by many. Thereafter, exceptions have been made to ensure all rights are protected under the order and to narrow the criticism faced by the principle. In the case of Trustees and Dennis Rye Pension Fund and Sheffield, the categorization of public and private law has now been altered towards a more substantive analysis whereby both can be taken under private law proceeding and judicial review process without quantifying abuse to the courts. With the facts adduced, Lord Wolf regretted that the tactical issue of choice of proceeding had inevitably led to very substantial costs being incurred to little or no purpose. He further criticised the narrow approach taken by House of Lords in Old Rook and Camden London Borough Council. In determining that question, the courts should not be overly concerned with the distinction between public and private rights, but to look at the practical consequences of pursuing the alternatives. Subsequently, Lord Wolf made three pragmatic suggestions to be considered. If it is not clear whether judicial review or ordinary action is the correct procedure, proceed to make an application for judicial review because it is a safer option compared to ordinary action, since it won't be treated as abuse to the court by avoiding the provided protection. If a case is brought by an ordinary action and then there is an application to strike out the case, the court should and ask itself whether if the case had been brought by judicial review when the action was commenced, clearly leave would have been granted. Finally, in cases where it is unclear whether proceedings have been correctly brought by an ordinary action, it should be remembered that after consulting the Crown Office, a case can always be transferred to the Crown Office list as an alternative to be struck out. After this encounter, a fairly liberal approach has been adopted in the case of Clark University of Lincolnshire and Humberside, where a student sued her university for breach of contract after failing her examination due to an unproven allegation of plagiarism. However, the university argued that judicial review was the best action of proceeding, although she had exceeded her 3 months time limit. The Court of Appeal disagreed, stating that the claim will not be struck out on the basis that the applicant proceeded under contract rather than judicial review. The introduction of civil procedure rule made it easier for the courts to deal with genuine abuse of process even though claim is not made under judicial review. The courts will now be taken into account all the circumstances delay in initiating the proceedings before making a concrete decision, because the accuracy of procedure no longer matters. Another case of point accepting a liberal approach is Mercury Communication Limited and Director General of Telecommunication 1996, where the decision has been distinguished from O'Reilly. A dispute arose between Mercury Communication and British Telecom, where both are public limited companies licensed under the Telecommunication Act 1984. Lord Sline emphasized that when determining the issue of choosing private or public law proceeding, flexibility must be retained. The court acknowledged the inappropriateness of the court trying to resolve a contractual dispute and therefore allowed the proceeding to be held beyond Order 53 under the commercial court without it being an abuse to the court. Lord Sline also stated that when it comes to a question of striking out an abuse of process of the court, at the discretion exercised by trial judge should stand unless the arguments are clearly and strongly in favor of a different result. A distinction can be made between a liberal approach and a restrictive approach, where Lord Lowry had examined the differences which were considered in the case of Broad. A broad approach lessens the importance of the distinction between private and public law and would allow either Order 53 procedure or pursuit of a private law remedy. A narrow approach, however, would dictate that if a matter is primarily a matter of private law, then the judicial review process is inappropriate. Overall, exercising this discretion too regularly would manifest unfairness and may undermine trust for public bodies and the legal system. With that in mind, effective reforms had made a contribution in reducing the unjust distinction and further acknowledging the factors. Thank you.
I'm Azita and will focus on issues arising where it concerns the relationship between private and public law under judicial review. On the face, it is safe to say the law protects public bodies over private interests as seen in the stringent nature of judicial review. However, this may not be such a bad thing, as the duty of public law is to protect the interests of the public and possibly reduce the work of the courts. Firstly, 3-month time frame has a good practical effect in that review is limited. Courts as well as public bodies do not have added work reflecting on the past. It creates a bottleneck which reduces matters brought to the court. However, this does not favor individuals, as 3 months may not be sufficient for them to get enough knowledge on the correct procedure. Even so, there is special exception for issues threatening fairness and natural justice. They are normally saved by the discretion of courts, as earlier mentioned in the case of University of Lincolnshire and Humberside. Another good control mechanism is the sufficient interest test. This one reinforces the court's reluctance to create a floodgate situation where just anyone can make a claim. Generally, only victims with local standard can make applications. However, the courts are also flexible where necessary, as seen in the case of Greenpeace. Also, civic virtue acts as another source of balance to ensure that reasonable concerned citizens can be allowed to act and hold public authorities accountable where it affects them or even not too directly. Concerning private and public law, the law is generally practical and fair. Firstly, the test of the existence of a public duty is an important first step in that it enables proper procedure in approaching its case. The aim is to establish that the body in question is actually under public domain. To establish this, courts use both precedent and statutes as reiterated by Lord Diplock in the case of Minister of State for the Civil Service. Secondly, the public function must also be established before courts agree to review a case. An example is the case of Datafin discussed earlier, where the court sought a body's operations to have public law functions and public law consequences. In the same case, the Barfoot test, in which the courts ask whether Parliament would have legislated to provide the performance of the particular function in the absence of the body in question, was also raised. Basically, this caters for the issues where the functions of a public body are not particularly clear and rely on the court's interpretation and discretion. All these parties make it harder for reviews to be allowed, but also ensure that proper procedure is followed and the rule of law upheld. However, some parts of the law need careful assessment to ensure that public bodies are not allowed to get away with wrongdoing. Because government departments can also misunderstand their legal position just like anyone else, abuse is inevitable, and so the law must provide a means to check it. Because of that, there is need for more transparency in holding public authorities accountable. For instance, the Criminal Justice Act 2015 allows courts to deny a review if it does not seem to have affected the outcome. Although this saves a lot of time, it allows public authorities to get away with a certain level of liability. Even if the outcome does not change, the expectations are that public authorities do not take shortcuts or become reluctant in how they reach decisions, and so accountability is required. Even if the review does not benefit the complainant, it will help in accountability, and reviewing government records would not go by the book. However, the existence of Oster clauses in statutes limits the jurisdiction of courts. If these are to work fairly, it must be ensured that there is still a transparency measure put in place to ensure necessity of such features. In an effort for courts to be limited as little as possible, a common law presumption has developed whereby access to the courts is not denied, save by clear statutory words. However, control measures are still needed where it concerns Oster clauses and why and how they are placed in statutes. In addition to this are non-justiciable matters, such as those involving royal prerogative, which the courts are reluctant to review. Even worse is the control of evidence by the executive through the Freedom of Information Act 2000. Basically, the law allows for people to apply for judicial review but limits what evidence they can bring before the courts by making it lawful for government departments not to release certain information. Although the Act introduced a test to improve transparency, its effect on judicial review will arguably be to reduce the number of applicants for judicial review, in particular on the basis of failure to give reasons. In other words, the law has undermined separation of powers in favor of the executive, making it even more untouchable. That said, improvements must be made to give the courts more power to review and hold the executive accountable as they do in private law, although it is hard and practically almost impossible. A possible reassuring and saving feature remains the obligation imposed by HRA for UK bodies to be in line with ECHR. In short, public and private law have a close link and must be separated to ensure fairness and public procedure. Also, a case-by-case approach operation of exclusivity of principle was precisely what Lord Diplock was applying for. When it comes to public law, accountability must increase in line with suggestions above what the justices served, as much as it is weight concerns private law as well.